mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar hablando de Kouri Richins. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, you guys, I did that little, anyways, listen. You guys, I know that you guys all saw that relatively recently Kouri Richins got sentenced to life in prison without the possibility of parole. Okay, so I wanted to talk to you guys a little bit about a sentencing brief that was submitted by the state prior to sentencing. So without any further ado, let's go ahead and get into it. Before we get into the brief precisely, let me just tell you guys some of my initial opinions, right? So as we all know that Kouri Richins was convicted of murdering her husband. So the first degree intentional murder of her husband, Eric Richins. And so basically because of that, her sentencing options are limited as to the first degree murder charge. So it's basically life with or without parole. Some states will phrase it differently. So I think specifically in Utah, it's like 25 years to life. So basically a possibility of parole after 25 years or life without parole. So basically those are the two options we're looking at when we're going into the sentencing. Okay. Does that make sense? Now I'm sure before I even read a word of this brief that the prosecution here is arguing for her to be sentenced for life without the possibility of parole, because it only makes sense, right? But anyways, without any further of my predictions, explanations, whatever, let's get into what the state asked the court to do at Kouri Richins' sentencing. As you guys can see here, it says state sentencing memorandum. The state of Utah plaintiff, Kouri Richins, defendant, Judge Richard Mrazek. On Valentine's Day 2022, Kouri Richins tried and failed to murder her husband and the father of her 3 young children, Eric Richins. Over the next 17 days, she did not think, what have I done? Rather, she thought, how can I do better? And then she murdered Eric in the presence of their children using poison and for money. Such a person should never again lurk among the rest of us. Her children should never worry that they may one day encounter her. Accordingly, the state requests that the court impose a sentence of life in prison without the possibility of parole. Kouri Richins has earned it. Her children deserve it. Only this court can order it. Let's stop right there. Am I right? Of course. Kidding, but I'm right? So they're asking for life in prison without the possibility of parole. How could I guess that? There's only two options. If this woman killed her husband, not if, she killed her husband, period. It's been proven, okay? She killed her husband. She did it in the presence of her kids. She calculatedly did it. She poisoned him. She did all these things. Life without prison or life without the possibility of parole seems like an adequate sentence. For the prosecution, that just makes sense, right? Obviously, on the other side, defense is going to be like, well, we think that she should have the opportunity to see her kids again. So life with the possibility of parole or 25 years to life makes the best sense here, right? But it doesn't surprise me that the state asked for that because, duh. Let's carry on. The state sentencing request. As to count 1, aggravated murder, the court should order the defendant to serve life in prison without parole, LWOP. Count 2, attempted aggravated murder. The court should order the defendant to serve 5 years to life in prison, consecutive to any other sentence. Count 3, insurance fraud. The court should order the defendant to serve 1 to 15 years in prison, consecutive to any other sentence. Count 4, insurance fraud. The court should order the defendant to serve 1 to 15 years in prison, consecutive to any other sentence. Count 5, forgery. The court should order the defendant to serve 1 to 5 years in prison, consecutive to any other sentence. The court should also enter a continuous protective order in favor of Eric Richins' family members that prohibits the defendant from contacting them unless they first initiate contact and prohibits her from maintaining or benefiting from insurance on the lives of the children. Eric's family members include the children: Jean Richins, Kouri Richins Benson, Clint Benson, MB and LM, and Amy Richins and Andrew Swenson. The court should order the defendant to pay restitution to Auto Owners Insurance Company in the amount of $1,017,018.49 and True Stage Insurance Company in the amount of $352,562.61. The court should further order the defendant to pay recoupment to Summit County in the amount of $1,391,943.98. Okay, let me stop right there and just explain a few things to you. Okay, so as we saw, as to count one, they're asking the court to sentence Kouri to life in prison without the possibility of parole. As to all other counts, they're asking the court to sentence her to a variety of different years, but consecutive to that life sentence. And we've talked about this before, but the sentencing options as far as how the sentencings or sentences shall run are consecutive or concurrent. Concurrent just means the time is grouped all one together, so you only serve one sum. Like, for example, if the court were to sentence Kouri to life in prison without the possibility of parole as to the murder, right? But then as to the other counts, sentence her to, additional years, but concurrent. All she's serving is life. Does that make sense? Does that make sense? What the prosecution is asking here is for the court to sentence her consecutively, meaning life plus 10 years, plus 5 years, plus 15 years. Do you get what I'm saying? So that's what they're asking. So in essence, you might be asking yourselves, well, Desiree, how does that really work out? Because if she's already serving life, she's already serving life. And that is true. But life plus consecutive sentences kind of just ensures that she never, ever, ever, ever gets out. Literally ever. And the court has the authority to do that. But let's carry on and see what else the state is asking of the court. Argument. When sentencing, the court is to weigh and consider public safety, punishment, deterrence, incapacitation, restitution, and rehabilitation. For consecutive versus concurrent sentencing decisions, the court must consider the gravity and circumstances of the offenses, the number of victims, and the history, character, and rehabilitative needs of the defendant. A sentence in a criminal case should be appropriate for the defendant in light of his background and the crime committed, and also serve the interests of society, which underline the criminal justice system. The court is to examine both aggravating and mitigating factors to include the nature and circumstances of the crime, the defendant's character, background, history, mental and physical condition, the impact of the crime on the victim's family and community, and any other facts in aggravation or mitigation of the penalty. Not all aggravating and mitigating factors are equally important, and one factor in mitigation or aggravation may weigh more than several factors on the opposite scale. A few aggravating factors may outweigh several mitigating circumstances claimed by a defendant. The psychological reality is that aggravating circumstances in first-degree murder cases will virtually always outweigh or be more compelling than the mitigating circumstances because the commission of a capital homicide, i.e. an intentional murder, is one of the most heinous acts known to society. The sheer emotional impact of all evidence of an unjustified killing tends to overwhelm evidence of mitigating factors in the mind of the sentencing authority. The court is to consider the totality of the circumstances in imposing a sentence that is proportionate to the crime and the culpability of the defendant. The court is not limited to the circumstances of the crime for which the defendant has been convicted, but may consider other factors as well. Evidence that is inadmissible at the guilt stage may be admissible for the purposes of sentencing. Such information must be reasonably reliable and relevant. Here, the state took the death penalty off the table in the early days of this case. Accordingly, on count one, the court must sentence the defendants to either life without the possibility of parole or an indeterminate term of imprisonment for 25 years to life. There is no presumption in favor of either of the two sentencing options. In totality, the egregious aggravators outweigh the perfunctory mitigators and require a sentence of life without parole on count one and consecutive sentencing on the remaining counts. The court should sentence the defendant to life without parole on count one. The nature and circumstances of the crime are irrational. The defendant murdered her husband in presence of their young children, using poison for money, and after trying and failing to murder him 17 days earlier. The Utah legislature recognizes that homicidal poisoning and murdering for money are each so heinous as to individually warrant the death penalty. Here, the jury found the defendant guilty of both aggravators. The defendant chose poison. Jurists throughout time have recognized the particularly heinous nature of homicidal poisoning. Of all species of death, the most detestable is that of poison, because it can, of all others, be the least prevented either by manhood or forethought. The Florida Supreme Court has called poisoning a conscienceless, pitiless crime. The California Supreme Court observed a murder carried out by deliberately giving the victim poison is more cruel and aggravated than other malicious or intentional killings, both because such a killing involves preparation and planning, and because the killer intentionally deprives the victim of any chance of escape or self-defense. The poisoner acts surreptitiously, thus avoiding detection, often betraying the most intimate trust. Here, the defendant betrayed the most intimate trust of her husband and her children. The defendant decided that Eric Richins' money was worth more than his life. Courts have consistently recognized that spousal murders motivated by money are especially egregious. In one such case, the Arizona Supreme Court observed the killing in this case did not arise out of a heat of passion, fear, struggle, or attempt to escape. The killing was not just the result of momentary premeditation, but of the defendant's deliberate, carefully conceived, meticulously planned, and cold-blooded scheme to kill rather than divorce his unsuspecting wife. The New Jersey Superior Court observed these killings do not stem from some powerful, visceral emotion, but rather from greed and expedience. Furthermore, few crimes display a more callous disregard for human life than the premeditated decision to seek profit by way of homicide. It evidences an abandonment of all rules that society has constructed to maintain communal life and warrants the fullest condemnation and retribution. B. The impact on the victim's family is irreparable. Fathers are not meant to bury sons, and losing a sibling is losing a piece of yourself. But there are no greater victims in this case than Eric's 3 young boys. The defendant took both of their parents from them. The aggravated murder was a crime of domestic violence in the presence of children. Eric Richins was a good husband. He cared and provided for his wife and even protected her from herself. Eric was a good father. He knew that the defendant tried to murder him on Valentine's Day, and he also knew that it was unsafe for his children if he were to leave the home. Eric died protecting his boys, and they know it. CR was 9 years old when his mother murdered his father. He is now 13 and wears his father's clothes to school. Following Eric's death, DYFS supported a finding of emotional and physical abuse by defendant against CR. He and his brothers have participated in intense therapy since the defendant was arrested 3 years ago. CR wants the court to know that my dad was a good person and very thoughtful and kind and helped whoever needed help, and that I'm afraid if she gets out, she will come after me and my brothers and my whole family. I think she would come and take us and not do good things to us, like hurt us. I miss my dad, but I do not miss how my life used to be. I don't miss Kouri, I will tell you that. AR was 3 weeks shy of his 8th birthday when his mother murdered his father. The defendant made AR her alibi, thereby condemning her child to be a material witness. If called to testify at trial, AR would have recalled being put to bed early on March 3rd, 2022 without bathing, which was unusual for the boys. The television was playing loudly inside his parents' bedroom, and when AR tried to enter, he found he was locked out. AR used a broom to try to dislodge a key from the above door frame, intending to unlock the door and enter the bedroom. AR accidentally hit the wall with the broom, making a noise that attracted his mother's attention. She yelled at AR to go away. She later entered his room and asked what he needed. AR pretended to be asleep because he was angry with her. Later during the night, his younger brother WR woke and tried to enter his parents' bedroom to sleep with them, as was his habit. WR also found himself locked out and slept in AR's bed instead. AR would have testified at trial that the defendant did not sleep in his room with him the night she murdered his father. AR wants the court to know that my dad can't be my coach anymore and can't be at any more of my games. He won't be at my birthdays. He can't teach me how to drive. He won't be at my graduation, and he can't take me camping or fishing. And that I don't want the defendant out of jail because I will not feel safe if she is out. With her in jail, I will be able to continue to feel safe and live a happy and successful life without fear of her hurting me or anyone I love. WR was still in preschool when his mother murdered his father. He has now lived half his life without his father and 3 years without his mother. His memories of both are limited. He remembers being scared the night of his father's murder and wetting his pants while held in the bedroom before his Aunt Katie arrived. WR wants the court to know, when someone talks about Kouri, it makes me feel hateful and ashamed. She took away my dad. And that if she got out, I would be so scared. I'm worried that she would take me away. Once she is gone, I will feel happy and I will feel safer and released and trust people more. If the defendant serves 25 years in prison, she could potentially be paroled at age 57. Her sons will be 36, 35, and 30, and likely will have their own families. The boys deserve finality and should not have to revisit their father's murder at future hearings or worry about the defendant's potential parole. Given the tremendous trauma and upheaval that the defendant inflicted upon their childhood, this court should ensure that she does not harm their adulthood. Not only should the defendant serve life in prison, but she should serve her boys' lives in prison. This is the best closure her children can hope for. Only this court can give it to them. Katie and Clint are now raising 3 boys that require extraordinary love, support, and stability. It is best for the boys and everyone is thriving, but Katie and Clint never planned for it. Katie never planned to administer an estate and a trust or tackle vindictive litigation. Gene never planned to work the family ranch at his age without Eric. Katie and Amy both live with guilt for not doing more to protect their brother from his wife. The aggravated murder's impact extends beyond Eric Richins' family. Josh Grossman bears the weight of knowing that he contributed to defendants' motivation to murder Eric. It has gutted him. Chelsea Barney bears similar weight knowing the defendant murdered Eric in some measure to salvage Miss Barney's life savings. It haunts Carmen Lauber that she unknowingly provided the defendant with the fatal drugs. Cody Wright and Josh Hayes question whether they could have done more to save their friend. The defendant's character is irredeemable. The defendant is transparent. Evidence of her character is well known from all stages of this proceeding, to include her prioritizing a facade of success over everything, her fraudulent borrowing, her stealing her best friend's life savings, her persistence in murdering Eric after failing on Valentine's Day, her self-publishing a children's book for money and attention, and the aim of her walk the dog letter, among a slew of other examples. The defendant cannot check her ambition or her sense of entitlement. When confronted, she lies. When she feels aggrieved, she attacks, and she certainly feels aggrieved. She always has. In the immediate aftermath of the guilty verdict, the defendant blamed a corrupt prosecution, a corrupt judge, and unfair Summit County jurors. 6 weeks following the guilty verdict, the defendant text messaged an admirer. I will expose this county, the prosecution, the judge, the Richins, the investigation, all of it. So they can lock me away for now. That's fine. It's going to come back on them. It will come to an end. Not this year or next, but I'm not going away. I won't be silent. I'm going to expose them all for what they have done to me, my kids, my family, this injustice. They picked the wrong one. They think sentencing is the end, closure, it's just the beginning. They haven't seen anything yet. Most telling of her character, the defendant attacked Eric. Within hours of her arrest, she for the first time blamed Eric for his own death. From jail, the defendant and her family engaged in open season on Eric the Dead, releasing what they believed to be damaging information about Eric to the media. During trial, the defendant falsely accused Eric of having an affair with a coworker and a homosexual affair with one of his best friends. The Richins children are familiar with the inescapable media coverage of this case. Many of the defendant's attacks against Richins' family permeate the record. For example, she throat punched Amy Richins 2 days after murdering Eric when Amy informed her of the Eric Richins Living Trust. Eric created the trust to protect her and their children. 4 days later, she hired counsel to breach the trust. She told Gene Richins that Eric died of the same lung mold that killed Gene's wife. Cruel. In the walk the dog letter, the defendant instructed her mother to release photographs of Katie's young children to the media and wrote, "Bring me home and then we'll get those damn bitches," referring to Eric's sisters. When confronted with the letter, the defendant insisted, in the face of all reason, that it was part of a freaking book, a half-true, half-fiction novel about her incarceration. Other of the defendant's attacks against the Richins family are new to the record. For example, when the estate's investigator found bank statements with Kouri Richins Realty's account header and C&E's account details, the defendant accused Katie and hired counsel to advocate for the criminal prosecution of Katie. While detained pre-trial, she caused her family members to pursue federal firearms charges against Gene for removing Eric's firearms from the Willow Court home for safekeeping, file false reports with DIFUS against Katie, and report Amy Richins to the police for marijuana possession. To this day, the defendant maintains insurance policies on the lives of her children. The Richins family will not be safe if the defendant is ever paroled. The defendant's attacks extended beyond the Richins. While detained pretrial, the defendant caused her family members to file unfounded bar complaints against the Summit County attorney and chief prosecutor and post a gay dating profile of the lead detective online. The defendant also made an unfounded criminal complaint to the FBI about Eric Richins' business partner. The defendant's character is evident. Despite her well-crafted facade, Eric's surviving Valentine's Day 3 years of pretrial detention and a resounding guilty verdict has only amplified the worst of her character. It did not remedy it. She has expressed no remorse and has indeed publicized the opposite. The irrational nature and circumstance of the aggravated murder, its irreparable impact on Eric Richins' family and others, and the defendant's irredeemable character prove overpowering aggravation. Any mitigation the defendant presents will only be more facade. It is all she is. It is all she has, but even if credited, it cannot outweigh the aggravation. Accordingly, the defendant has earned the maximum punishment, short of death, and public safety requires her permanent incapacitation. She has well established that rehabilitation is beneath her. Life without the possibility of parole, combined with the intense publicity cultivated by the defendant and her counsel, will also deter would-be poisoners from coldly murdering their spouse and their child's parent. The court should sentence consecutively on counts 2 through 5. The gravity of the attempted aggravated murder is that the defendant learned from her mistakes. She learned to obtain something stronger and to administer it in a way that prevented Eric from realizing the poison's effects until it was too late. The circumstances of the attempted aggravated murder are identical to the circumstances of the murder. The gravity and circumstances of the frauds and forgery punch above the charge's weight because they encompass the defendant's murder for murdering Eric and the pecuniary gain aggravator. The defendant's character is irredeemable. Accordingly, the defendant earned distinct punishment for counts 2 through 5, and the court should sentence them consecutive to any other sentence. The court should enter a continuous protective order in favor of Eric Richins' family members. The defendant was convicted of domestic violence, aggravated murder, and attempted aggravated murder. Utah's Criminal Protective Order statute provides that when a perpetrator is convicted of a domestic violence resulting in a sentence of imprisonment that is to be served after conviction, the court shall issue a continuous protective order at the time. Sentencing limiting the contact between the perpetrator and the victim unless the court determines by clear and convincing evidence that the victim does have a reasonable fear of future harm or abuse. The protection may include any order that the court considers necessary to fully protect the victim and members of the family. Here, Eric Richins is the only victim under Utah's crime victim statute. Paradoxically, Eric Richins' family members, including his children, are not victims. It is evident that Eric Richins does not have a reasonable fear of future harm or abuse, which is the Criminal Protective Order statute threshold inquiry. Thus, the Criminal Protective Order statute yields the absurd result that the family members of domestic violence murder victims are left unprotected when family members of all other domestic violence crimes can be protected. This is where the absurdity doctrine comes into play. Courts will apply the absurdity doctrine when the operation of the plain language is so overwhelmingly absurd that no rational legislator could have intended the statute to operate in such a manner. This standard is satisfied only if the legislator could not reasonably have intended the result. The standard is satisfied here. Clearly, the legislator could have not reasonably intended to accept the family members of domestic violence murder victims from protection. The defendant's conduct in the victim impact statements firmly establish that it is necessary for the court to protect the children from their mother, as well as Eric's father and his sisters and their families. Anyone can appreciate the family's fear resulting from the defendant maintaining insurance on the boys' lives. Accordingly, the court should issue a continuous protective order under these sections that prohibit the defendant from contacting Eric Richins' family members unless they first initiate contact, and prohibits her from maintaining or benefiting from insurance on the lives of the children. The court should order the defendant to pay restitution. Utah's Crime Victims Restitution Acts require district courts to determine restitution for any pecuniary damages proximately caused by defendant's criminal conduct. Insurance companies are victim under the statutory definition. Additionally, the defendant is a killer within the meaning of Utah's so-called Slayer statute, which provides that a wrongful acquisition of property or interest by one who kills another shall be treated in accordance with the principle that the killer cannot profit from the killer's wrong. The defendant received over $1 million from Auto Owners Insurance Company and over $300,000 from True Stage Insurance Company as a beneficiary of insurance of Eric's life. These insurance companies paid out as the result of the defendant committing aggravated murder as convicted in count 1. Moreover, True Stage paid out because the defendant committed insurance fraud and forgery as charged in counts 3 through 5. Accordingly, the court should order the defendant to pay the restitution in the listed amounts. The court should order the defendant to pay recoupment to Summit County. After Ray, Queen, and Nebaker abruptly withdrew from this case in May 2024, the court declined to require the defendant to complete an affidavit of indigency, citing Fifth Amendment concerns. The court found that the defendant was indigent on the sole basis of former counsel's representation that the defendant does not have access to financial resources sufficient to retain private counsel. Summit County thus became statutorily obligated to provide defense services to the defendant. The cost will exceed $1 million. If the court learns that an individual provided with indigent defense services is in fact not indigent, the court shall order the individual to pay the indigent defense system the cost of services. The defendant continues to litigate claims to Eric's premarital home and share of the trust rests. To the extent any of these assets or any other assets are adjudicated to the defendant's property, the court must order over $1 million of those assets paid to Summit County as recoupment for indigent services. Additionally, the court may order a defendant to pay costs for the expenses incurred by a political subdivision of the state for attorney fees of counsel assigned to represent the defendant. To the extent that the defendant or her representatives or assignees receive any money that is not subject to the Profit from Notorious Criminal Activity Act, the court shall order over $1 million of that money to be paid to Summit County as recoupment for indigent defense services. Conclusion. The court should sentence the defendant to life without parole among the state's other sentencing requests. This sentence is appropriate considering the crimes that she committed, their impact on her children and Eric Richins' family, and her irredeemable character. The sentence serves the interests of society, which underlie the criminal justice system. Most importantly, no other sentence can provide the children the comfort and protection they need and deserve. So let's go ahead and get into what the court actually sentenced Kouri Richins to before I give you my opinions.
Having considered the gravity and circumstances of the offenses for which Ms. Richins has been convicted, the number of victims, and available information regarding the history, character, and rehabilitative needs of the defendant, the court hereby orders that the sentences on counts 2 through 5 shall run consecutively to each other and to the sentence imposed on count 1. Moreover, the court exercises its discretion and chooses to impose no fines related to any sentence in this case. The court addresses the 5 counts on which Ms. Richins was convicted in reverse order. Ms. Richins, based on your conviction on count 5, third-degree felony forgery, the court hereby sentences you to an indeterminate prison term not to exceed 5 years. Based on your conviction on count 4, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 3, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 2, first-degree felony attempted aggravated murder, the court hereby sentences you to an indeterminate prison term of not less than 5 years, and that may be for life. Which brings us to the final issue, the appropriate sentence for count 1. Kouri Richins was convicted unanimously and beyond a reasonable doubt of attempting to murder Eric Richins, her husband, and the father of their 3 children. And then, having failed in her first effort of spending the next 17 days, not changing course, but doubling down, preparing to try again, and ultimately completing the act through the administration of poison. And for what? Money. All for pecuniary gain. A person if convicted of committing that sequence of acts in that way and for that reason, and who causes the absolute tragedy that has befallen Eric Richins' sons and family. A person convicted of those things is simply too dangerous to ever be free. Accordingly, Ms. Richins, based on your conviction on count 1, first-degree felony aggravated murder, the court hereby sentences you to life without parole.
Okay, so the court sentenced Kouri as requested by the prosecution. Life in prison without the possibility of parole, and the sentences for the other charges to run consecutively to the life sentence. Okay? Am I surprised by that? Not at all. Not at all. Not at all. Not in the slightest. Let's talk a little bit more about the brief and what my opinions are on the brief that the prosecution submitted. There are some things in this brief that I didn't even know. it stated that Kouri's over here talking about the prosecution and the judge. She created an online profile for the detective. She's doing a bunch of irrational things. I think that this sentence or these sentences will bring comfort and solace to her children. I also wonder, and let me know who it is or who you guys think it is, because it said that she was texting someone, some male suitor or some lover, about how everyone was going to get it. Like everyone is going to get their payback or whatever. That's so extra and dramatic and crazy. But that is it for this Kouri update. Mayor Bear, I did it for you. I did this for you. I hit myself on the microphone again. I love all of you guys. I love all of my supporters. I love the fact that you're here with me. Like I told you last time, I'm going to continue to say this in all my videos until we get it right. Okay? I pre-record a lot of these videos. So a lot of times, if you don't see me uploading a video, it's probably because I'm working on recording a video and then editing the video to get it back uploaded to you guys for you to see and for you to enjoy. Please do me the favor of liking, commenting, and subscribing if you enjoyed my videos. If you want to keep up with me, if you want to see what else I analyze, if you want to see what other cases I discuss, it's best to be subscribed. Also, you guys, hold on. Do you guys have your notifications turned on? If you haven't checked that, go ahead and check that for me because I drop videos pretty frequently. I would say at this rate, maybe 1 to 2 times per week. And I just want to make sure that you're getting the notifications of every time I drop a video because I don't want you guys to just be focused on one case that I'm discussing. I want you guys to see the plethora of cases that are being discussed on this channel. But that is it for this video. Thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.